I think we're going to try to stay on schedule here and get started with the next panel. Our next panel is on creative approaches to disclosure and third-party records applications. Perhaps a dull-sounding title, but two exceptionally creative and interesting litigators we have here today to speak to you about it. On my left immediately here is Chris Murphy. Chris has practiced criminal law in Toronto since 2004. He now lives in Saskatoon and maintains a practice both in Saskatchewan and in Ontario. To his left is Danielle Robitaille. Danielle and I have practiced together for I think 15 years now. She's now the managing partner at Henein, Hutchison, Robitaille, where she rules with an iron fist. Danielle and Chris.
Thanks very much, Matt. It's our pleasure to present on this topic, and we want to do a couple of things today. We're not going to take you through our PowerPoint materials, but I'm going to spend some time introducing the topic. Then we're going to hear from Chris on the practical realities of the topic in his region. We're going to offer some practical, hot practice tips, and then I'm going to close off with the role of the Crown in this area. But by way of introduction, what I would say is I love coming to the CLA conference annually, and I think one of the benefits of attending every year is it has this kind of renewal force in our practice. It has this ability to re-energize and re-engage us in the practice of law, and in particular in this practice area, which is so challenging. And we're learning more and more about why it's so challenging emotionally and intellectually. And I think one of the things that's challenging about criminal law for many of us who did undergraduate programs in political science or sociology is we may have gone into the practice with this idea that we could make a difference, that we could change the world. And the reality for day-to-day criminal practice for many of us is we are really helping one guy at a time. And it can lead to a sense of cynicism when we see some of the structural systemic problems in the system over and over again with no real opportunity to change them, except to assist, as I say, one guy at a time. But the exception is this area where we have an opportunity to point the court to systemic issues. And there are a number of areas in the case law and in our practice where we have the ability to do that. But of course, most of the time we're focusing on 24.1 or 24.2, where the systemic breach could lead to a stay of proceedings or exclusion of evidence. And how do you get to a point of advocating and asking a court to find a systemic breach? Well, we say, Chris and I will put to you today, that you need to make use of the O'Connor regime to get the evidence that you need to establish systemic breach and get the result you need for your client, but more impactfully can make and has the potential of making a systemic difference to the system as a whole. In your materials, you will see what is a very substantive PowerPoint, and we were ably assisted by HHR Articling student Brendan Alexander in putting it together, but it is a non-academic paper in PowerPoint format, and it goes through the O'Connor test, lots of case law showing the different ways systemic state abuse is relevant to your practice. So I really commend the PowerPoint to you. Some of the hot tips that we're covering in our presentation are laid out in the PowerPoint, but I really think that you ought to take a look at that. And it's formatted in a way that's completely different from our presentation. So please take a look when you have a moment. I want to throw it to Chris, who's practicing in Saskatchewan at the moment, and who has really had a ton of experience with dealing with systemic state abuse in the context of serving individual clients in the criminal system. And Chris, if you could just take it away and describe a bit what you're doing in Saskatchewan.
Thank you. Good morning. So I moved to Saskatoon during COVID in 2020, and one of the first things I noticed that I hadn't noticed when I was growing up in Saskatoon was that it's different than Toronto. And specifically, I believe that the way that the criminal justice system operates in Saskatoon is different, and I don't mean that in a good way. So in Saskatchewan, right now, the percentage of girls who are Indigenous in custody, so under the Youth Criminal Justice Act, between the ages of 12 and 17, is 98%. And I would suggest to this group that 98% of us probably don't believe that the earth is round, right? And so that's the starting point. And throughout the last 4 years, I had a number of cases that were farmed out by the staff legal aid system to me. And staff legal aid in Saskatchewan pays about $92 an hour. So people in, Ontario are pretty well off in comparison. But I had 5 cases that were Indigenous men who had been arrested for serious offenses such as loaded firearms, lots of drugs, weapons, etc. But they had all started off with bicycle stops. So in Saskatoon, there's the downtown district where most of the crime happens. And it turned out that the 5 cases that I just had happened to come across my desk were all Indigenous men riding bicycles in downtown Saskatoon. And so the premise of the stops were literally riding a bicycle with no bell, right? Riding on the sidewalk for a number of seconds, riding at night without a light. So my mom's 77 years old. She lives in Saskatoon. She bikes year round. No one's ever stopped her for riding without a bell, right? And so it became apparent to me, at least, that this is a systemic problem. But the problem is that it's difficult to prove. So I go to a JPT and I say, look, I've got 5 of these cases. Like, the Crown should just drop this. And the judge literally says, well, you should be a witness in one of these trials. So that was like literally the response. I said, well, I can't do that. So I ran one of the cases, brought a section 8-9, 24-2 guy riding without a light, and I just didn't have it. I didn't have the evidence that I needed to be able to establish the charter breach. And I walked out of that courtroom knowing 2 things for certain. Number one, that this is a systemic problem, that there's a systemic and cultural attitude amongst the Saskatoon police, and frankly amongst the administration of justice, that is allowing this to happen. And I said, this is never going to happen again, to me anyway, to go out in this fashion, to lose in this fashion. And then I was on a plane with a police officer from Saskatoon, and I raised it with him, just randomly sat next to him. And I said, guys, this is unconstitutional. And he said, this is good police work. We're using the options that are available to us, right? So the next case I had, I brought the pretrial application to have the charges stayed and or the evidence excluded. And the facts of that case were that, again, man riding on a bicycle, 5 in the morning. In Saskatchewan in the summer, it's light out at 5 in the morning. And so literally nobody on the street, nobody on the sidewalks. Police say that they see him from a distance, half a block away, and they immediately decide they're going to give this guy a $50 ticket for riding on the sidewalk. And what ended up happening, and I'm under a court order to discuss some of this, but not all of it, is that I brought an application, ultimately brought an O'Connor application that was mid-trial, and the judge, and I'm reading because I have to be careful what I say, the judge ultimately concluded that the records that were released And the records that were released were the records for the individual officers for every ticket they had ever handed out under the bicycle bylaw, but more importantly, every ticket that any officer at the City of Saskatoon or the Saskatoon Police Service had handed out in the previous 2 years. And Danielle was saying that this is like an O'Connor application is like a defense search warrant. And I felt as though, like, when I got this disclosure, because I knew, everyone knows what's going to be in it. Of course, there's going to be racial profiling, right? But it was like I felt like I would if I were a Toronto drug squad officer kicking down a door, because I knew there's going to be stuff in there that I was going to be able to use for my own use. And so then the judge made a finding that there was evidence that primarily Indigenous individuals are stopped for bicycle bylaw infractions, and that could support the inference that the stop of this particular accused was discriminatory. And she also said that the records overall appear to suggest that there was a vast majority of people who are ticketed under the bylaw who are Indigenous, and the tickets are primarily issued in the downtown district. Okay, so that was the ultimate finding. Now, in order to get to that finding, we had to bring the application, and the way it panned out was that we ultimately got the records. Then I brought an application under Aries and Venner for the admissibility of the documents at the trial. The next day, the Crown stayed the charges against my client, right? And, I have my suspicions of why. My suspicion is that they didn't want the judgment that was going to come out as a result of this case. So I had been under conditions of how these third-party records could be used. So at that point, the charges are stayed. I go back before the trial judge. I bring an application to get back before her, and I say, listen, I'm hoping to be able to use these records for the better good, right? I want people to know about this. I want the media to know about this. And the judge said, yeah, no problem. So I ordered the transcripts. Next day, I got an application for certiorari from the Saskatoon Police Service to go to King's Bench to quash the order of the trial judge that allows me to talk about this. And the reason why, the reason for the order was that they said that the police's position was that the judge was functus now that the charges had been stayed. So I go to the Court of King's Bench to argue this. Ultimately, the King's Bench justice concludes that the trial judge was functus, and that I'm not really allowed to talk about it other than what's in the trial judge's judgment, which the police were trying to have me not be able to talk about as well. And so that's the kind of the systemic force that people who are trying to push this rock up the hill are facing, especially in Saskatoon. And one of the things that struck me, and one of the things that I believe that everyone should keep in mind when they're bringing these types of applications, is O'Connor says that the defense can't be held to the standard of knowing what the records are going to do, what use we can make of them, because we haven't seen them. And so you're kind of placing your trust in the record holder to tell the court what the relevance of them are. So the Saskatoon Police Service head counsel came to court, and this was after the judge had been provided with the records. And the judge was asking questions about, well, the judge believes that these records were likely relevant for my application to prove racial profiling. And the police service lawyer said that the court would just be, quote, guessing if a person was Indigenous if they had the person's mugshot and their last name. Okay, so my guy's last name was Baldhead. It's a typically Indigenous name in Saskatoon. But the police's position was that if you had their mugshot and their last name in front of you, and their name is Baldhead, you can't use that to prove racial profiling because you'd be speculating if that person was actually Indigenous. This is the Saskatoon Police Service. She's King's Counsel. She's making that submission to a court, okay? So I stood up and I said, this is exactly the problem that everyone is facing in the criminal justice system. And I said this to Emma Rhodes a few minutes ago. It's almost as though Saskatoon is in a pre-racist society. You don't even actually acknowledge that racism exists, right? Because if the police just happen to be pulling over 98% of the people, of Indigenous men who are riding bicycles in downtown Saskatoon, and they literally don't know that the people they're pulling over are Indigenous, then how can they ever self-assess and determine whether or not they have subconscious biases against Indigenous people? It's impossible. So the starting point, I think, is to recognize how hard this could be. And you know, Danielle just said that this conference can be a renewal force. And I think that hopefully that I can help renew your enthusiasm to go out and just keep pounding on the drum. And not only can we get the judgments that help society, help us advance these causes, but it actually does trickle down to the officers involved. And sort of my coup de grace was I got a call a few months ago from a colleague, another criminal lawyer in Saskatoon, and she said, I just listened to some in-car video on a bike stop, and the cops were like, it's fucking Chris Murphy. is making this hard on us. Something to that effect. That wasn't not a direct quote. But, you know, they will take notice, and they'll have to if ultimately the records that you get demonstrate what you know is going to be in them in the first place. And now I'm just going to turn it over to Danielle for some hot tips.
Yeah, so I'm not under any court order. And what I'd say is, you know, you read those paragraphs, and what the trial judge is saying, though they're not saying it, is that Chris successfully obtained records that would allow him to prove systemic racism in this particular context, right? How powerful is that? And you all have the ability to do that, and you should be inspired by Chris's work doing that in Saskatoon at $92 an hour. And we urge you to spot these cases and go for it, but you have to meet the likely relevance threshold. How do you do that? You need to look at a variety of sources, and my former partner, now Justice Manville, was just a genius at this, and she would do it in all sorts of contexts in O'Connor applications across her broad practice when she was practicing. She would bring ATIP requests and FOI requests. So ATIP is the records regime for federal agencies, state agencies, and FOI is the regime for provincial agencies. You should also be aware that the Globe and Mail has produced this website called secretcanada.com, which has archived and created a database of FOI requests requested and produced by journalists. And so it's a huge, massive database that you can go on and look for Ministry of Correction records and see if there's something there that's relevant to your charter application that can help you get over the hurdle of likely relevance. So you're not going to get the records you look for by just asserting in court. I think there's something fishy here. You have to kind of establish the building blocks. And one way is getting access to records that, just as a Canadian citizen, you have a right to get access to. You can also file newspaper articles. You can look at academic studies and books. You can look at case law where there have been previous findings of issues relevant to your charter application, human rights reports, commissions, and reviews. If there's a reporter in your town who's on this beat, we're very lucky to have the Toronto Star here in the city with journalists who are working on the issue of police misconduct, for example. Call them up. They will have off-the-record discussions with you about things that they're seeing, trends that they're spotting, which might give you a lead on how you can get records that you need access to get to the likely relevance threshold. But let me just kind of pan back, because before you get to likely relevance, you need to spot the potential for a systemic issue. And there are a couple of things that you need to do to be in a position to spot the potential for systemic state abuse. The first is self-study. You just really need to be, I sound like Matt Gourlay, you gotta read every case coming out of the Court of Appeal in your province every week. You need to be on top of the case law to understand what is going on the ground, on the front lines. You need to stay connected to your colleagues and speak to them about their cases, about what they're seeing, what their clients are experiencing. You know, Chris had the benefit of being randomly assigned as a staff legal aid lawyer to these 5 cases, which allowed him to spot the systemic issue. If you're not speaking to your colleagues, you won't know what everyone else is litigating, and you may miss that systemic issue. Most importantly and relevant, particularly today, where we had that amazing professor from Haifa and his charming presentation on listening, you have to listen to your client. You have to really listen to them. And you have to get them to take you through their experience in custody, their experience of being arrested, and hear them out. And if you cover those things, you'll be well positioned to spot a potential systemic issue, and then you can turn your attention to how you get the building blocks to get to likely relevance. And so, you know, my preference would be to walk into court with an application record that is just inescapable, that the trial judge would have no choice but to order production of the records. But sometimes it's not so easy, and Chris can take you through an example of like what I like to call like a dirty O'Connor.
So, okay, yes, so to use it as example, this bald head case again. So after the first case that I lost, you know, I said, well, okay, what's the approach to prove this next time? And it's really difficult, and I hadn't thought of the FOI, and I'm not sure if that would have helped in this specific case or not, but sometimes it's really difficult to demonstrate that it's not a fishing expedition. And so I filed just the standard kind of boilerplate Section 8 and Section 9 and 24-2 application to demonstrate that this was an arbitrary detention based on, the stop was based on racial profiling, okay? So sometimes something can fall into your lap. And what happened in this particular case was the Crown Attorney had received the notice of application, obviously, and had advised the police that the notice had been filed. And in examination in chief, the Crown Attorney basically asked the arresting officer, well, who do you give these tickets to? You know, and of course, his answer is, well, I give them to everybody. I give them to old ladies riding in the good parts of town. I give them to old men riding in the other parts of town. They're white, etc., right? Which obviously was not correct. And he said that he had given up upwards of 100 bicycle bylaw tickets. And he actually used that number. This is an examination in chief. So that examination in chief obviously opens the door for extensive cross-examination in relation to what the records actually said, right? And ultimately, what the officers will almost always admit is that they're not racist, right? They'll say that they do not police based on skin color. And they'll say that, they'll say that they've never had any training in whether they should look introspectively about if they have subconscious biases. And they'll also say that nothing they do is motivated by race. And that gives you an opening to be able to get from them and advise the court that this is the systemic issue, that they haven't ever looked inside themselves, so we need to get the records from them and the police department to determine whether or not this is a systemic issue. And so ultimately, as the trial judge said, the vast majority of these tickets that were handed out by this officer were to Indigenous people on bikes downtown. And ultimately, you can demonstrate through the records that the evidence is not credible, but also more importantly, that it's systemic.
The last thing that Chris and I want to urge on you is the role of the Crown in these sorts of applications. So the reason we're in O'Connor when we make these applications is because the records are not in the Crown's brief, right? They're not the fruits of the investigation. They're records that are housed in other state agencies, either the police service, a corrections ministry, what have you. So you may want to consider, as a starting point, before you go through the expense and trouble of bringing a full O'Connor application, of writing to the Crown and imploring them to make inquiries. And I have kind of like a secret rationale, and I'm going to share it so it's not so secret, about why we want to do that. My favorite criminal law case is McNeil, 2009, at the Supreme Court of Canada. There are several paragraphs in that case that set out two fundamental propositions, in my view. First, a Crown's position in the disclosure process is non-adversarial. A Crown's position in the disclosure process is non-adversarial. The Crown and the defense are in the same position vis-a-vis disclosure, getting the information in the hands of the parties to properly litigate the case. The second proposition, the Crown is not a passive recipient of disclosure from the police. The Crown is not a passive recipient. And so if you have enough evidence to reach a certain threshold to say, look, Crown, I'm concerned we're dealing with a systemic issue on the following area. I'm seeing this pattern, but you're welcome to disabuse me of this notion. Can you request the record from your sister agency so we can both take a look to see if there's anything there? Now, I appreciate that's a highly cooperative conversation, and that many of the Crown attorneys that we're encountering day to day will think you're crazy if you're having that sort of conversation. But I urge it nonetheless, because I don't think we should normalize this adversarial, passive position that some of our Crowns are taking in these cases. I think we want to invite them to join us in the project of uncovering the truth, because they should not be adverse to that project. They should join you in that project. And you write that letter, you have that conversation, they turn you down, you bring your O'Connor application, you're ultimately successful, but guess what? A whole bunch of delay has accrued. And you have just a gorgeous letter in your 11B application record showing that you tried. You really tried to save time and to cut to it and get to the issue that now, in retrospect, was obvious all along. That's pretty much our time. I don't think it's a questions thing, eh, Matt? We don't do questions. We have 2 minutes if there's a question. McNeil? Yes, McNeil, 2009, Supreme Court of Canada. My fave. And it's in our PowerPoint presentation.